Ready? Exercise number 22, legal matter, start. Intermediary Guidelines and Digital Media Ethics Code Rules 2021 notified towards the end of February by the Ministry of Electronics and Information Technology should not come as a surprise because it is of a piece with the systematic incremental erosion of the freedom of speech and expression. The fate or the final shape of the notification will depend on the way the two petitions already filed against it in courts in Kerala and Delhi are decided upon. But the more worrying aspect of this clumsily wheeled move by the executive to keep the media, particularly the stand-alone digital news media, which have generally proved more defiant and inconvenient for the government than the mainstream press or television channels, on a leash is the way it invokes and insinuates the idea that the public or the users need to be protected against the very media that in fact seek to make them critically informed citizens, thereby making their democracy that much richer and deeper. Stop, next para. For all appearances, the overarching intent of this new set of rules is to put in place a grievance redressal mechanism for the end user or consumer of social media and over the top under bracket OTT bracket out platforms and the digital news web portals. That of course would normally be an unexceptionable public purpose, but in an already vitiated climate of overweening political and religious majoritarianism, where the street trends to and is often egged on to whip up and aggressively nurse and drive a sense of outrage or hurt on any and every issue, irrespective of institutional procedures or safeguards. The nature and scope of the bulk of grievances can easily be imagined. Further, the smaller or medium-sized independent digital news and current affairs portals, which are for the most part struggling to stay afloat irrespective of whether they are newer startups or have been around for a few years, will be the ones hardest hit by this redress requirement. Any criticism of the ruling party or government could trigger an orchestrated avalanche of grievances. The notified rules set out an elaborate time-bound three-tier process whereby each and every such grievance is first handled at the level of the portal itself by its own grievance officer and if not satisfactorily settled passes on to the self-regulatory body of the sector or industry, and if yet not resolved moves further up to an interministerial oversight committee of the central government. The sheer process of such grievance handling can stymie the operations of a relatively smaller digital venture in the news and current affairs space. The process further makes a mockery of the concept of self-regulation, with an interministerial committee of government officials in effect becoming an appellate authority over the self-regulatory exercise. This would be self-regulation by the media organization and the industry at the government's pleasure. Regulation by the government masquerading as self-regulation by the news media entity or industry. What is worse, the notification gives the Secretary, Ministry of Information and Broadcasting ad hoc emergency powers to block any content the government considers problematic even without such token procedure. Negation through distortion of the idea of self regulation is really the nub of the matter, at least as far as the section pertaining to publishers of news and current affairs in the notification is concerned. Full stop. Thank you.